Morning, Justices. May it please the Court, my name is Jack Wilson, and I'm here to represent your appellant, Jerry Ferguson, and I'd like to reserve 3 minutes for rebuttal. This appeal arises out of a suit for ejectment from a riparian zone in Middlesex County involving an island and a causeway in the Rappahannock River, and this Court granted an appeal on 4 assignments of error. And the first I'd like to address is the assignment related to statute of limitations. The original complaint in this case was a claim for ejectment, a claim to eject Mr. Ferguson from the riparian zone of the plaintiffs. And there's no dispute that Section 8.01-236, which provides for a 15-year statute of limitations, applies to this type of action. The question before the Court is, when did the cause of action accrue for ejectment? And the facts are not in dispute. The Bosemans, now the Stokes are the heirs of the Bosemans, purchased their property in 1977. And at the time they purchased their property and came in possession of it, the island and causeway that are in the Rappahannock River were in existence, clearly in view at the time, and had been, the record shows, since approximately 1960. The complaint for ejectment herein was not filed until 2011, well beyond a 15-year statute of limitations. So we contend that the cause of action accrued under 8.01-230 in 1977, and therefore 15 years later the cause of action for ejectment expired. The fact that the Bosemans perhaps had not made a specific determination during that 15-year period where their riparian zone may have been did not in any way toll the statute of limitations. They were put on notice that there was an island and causeway in the river adjacent to their property, and so to some extent, whether they knew it or not, the island and causeway were within their riparian zone. The Stokes contend that there was a 2008 settlement agreement involving other litigation, and the Stokes contend that release, which is in the record, somehow specifically revived or renewed the statute of limitation and created a new right of entry. But there is absolutely nothing in that document that would suggest that there was any tolling of the previous statute of limitations or that some new cause of action had been created by the settlement agreement. So therefore, we believe that there's nothing in the settlement agreement from 2008 that would have created a new cause of action for ejectment, and therefore the trial court made error when it ruled that the statute of limitations defense was to be denied.
What about the release in the settlement agreement that says that Mr. Ferguson was giving up really any claim he had? You know, you name it: demands, damages, debts, liabilities, obligations, duties, causes of actions, actions of law, and certainly a statute of limitations can be waived. Why wouldn't he have given up his right to assert the statute of limitations and sign in the settlement agreement?
Well, again, Your Honor, the release was mutual. So likewise, under that same release, the Bosemans at that time released all claims, causes of action whatsoever they had against Ferguson.
That's true.
And so likewise, to that extent, our position, though, is in 2008, the statute of limitations for ejectment had already expired. So there was no claim for ejectment that could be revived by that settlement agreement.
Well, it's not the claim for ejectment that we're talking about reviving. It's the assertion of the statute of limitations by your client that we're wondering, that I would wonder whether or not it was waived by the settlement agreement.
Again, I don't believe that the waiver of that releases and waives any causes of action, but it didn't necessarily waive or release any defenses that would be brought against Mr. Ferguson as a result of that cause of action that would be later brought. At that time, he was releasing any claims he had or may have had against the plaintiffs or the Bosemans, and likewise the Bosemans waived and released all claims they had against him.
Wasn't one of the claims that he waived and gave up in the settlement agreement a claim that and that they gave up as a claim for ejectment and his right to say no? It started a clock running over.
In the 2008, there wasn't the underlying claims for ejectment had not been raised. I think the 2011 was the first time that the claim for ejectment had been filed. 2008 involved some other claims, including adverse possession that Mr. Ferguson had brought, trying to claim by adverse possession rights to the riparian zone. All of those claims got settled in 2008. Key to the settlement agreement was the obligation of Mr. Ferguson to purchase the Bozeman's property. That purchase never took place, and therefore that's what resulted in the subsequent 2010 order that's also part of the record. But there was nothing in the 2008 release that would revive a claim for ejectment that had already expired. The second assignment of error relates to the pleading requirements and whether Mr. Ferguson had to specifically plead Section 28.2-1200.1, which is referred to in the briefs as the 2011 statute. That statute, which became effective on October 1, 2011, provides a mechanism by which state-owned river bottoms can become the private property of individuals. In a claim for ejectment, the plaintiff has the burden of proof to establish superior title. And here we were dealing with riparian rights, so the underlying real estate had to have been owned by the Commonwealth for the Bozemans to have a claim for ejectment from those riparian rights. And in their complaint, they did allege that the Commonwealth owned the river bottoms that were at issue here, and that allegation was specifically denied in the answer. That put the plaintiff at the trial on the burden of proving then superior title and that in fact the Commonwealth owned the river bottoms. Thereafter, in the course of discovery, Mr. Ferguson did specifically mention the 2011 statute as a basis for his denial that the Commonwealth owned the river bottoms. And again, that was the appropriate notice to the to the plaintiffs, to the Stokes, that Mr. Ferguson was denying that the Commonwealth owned the river bottoms, and therefore the Stokes had to prove that the Commonwealth owned those river bottoms.
Counsel, with regard to the statute and the trial court's decision on the statute, it seemed like the trial court, in my view, made three findings with regard to the statute. One, that it was affirmative defense, you had to plead it and you didn't. But even if that wasn't true, that you didn't meet the elements of it. But it seemed like there was a third one, both in the letter opinion and also in the final order, that Bozeman's rights were vested by the court's 2010 order and could not be diminished by the 2011 amendment to the statute. And my question is, I'm not sure that is a subject of an assignment of error in front of this court, and if it's not, wouldn't that be an independent basis for the courts to affirm the court's ruling with regard to the application of the statute here?
Well, again, the 2010 order that supposedly vests, what that order does is specifically provide and find that the Commonwealth, as of that time, 2010, was the owner of the river bottoms. The Commonwealth owned the state-owned or state river bottoms. That would not necessarily... But
it established the Bozeman riparian rights, too, didn't it?
And it did. At that time, it established the riparian rights. And at that time, those would be riparian, because the statute at issue did not become effective until 2011.
But my question is not to the merits of that, but the trial court, right or wrong, both in his letter opinion and in the order, and in his paragraph 11 in the order, says that plaintiff's rights, as set forth in the order dated March 2010, it gives the name of the case, are vested and cannot be diminished by this code section that was enacted in 2011.
And that would be, again, what the trial court would be saying is that the 2010 order somehow would preclude the Commonwealth.
Well, I know what he's saying. I don't know whether it's right or wrong.
But
my question to you is, it seems to me that's a basis for the court saying the statute doesn't apply here, and I don't find that to be a subject of an assignment of error here.
You're correct, Your Honor. Yes.
Okay.
But again, the point on that vesting issue was the order is not erroneous. The 2010 order specifically says that the Commonwealth owns the river bottoms and the portions of the riparian zone of the Bozemans based on that. But that order would not preclude the Commonwealth from later, which it did, provide a mechanism for those river bottoms to be owned by private individuals, and no longer then would the underlying river bottoms lead to riparian rights. The third assignment of error did deal with the specific points of the 2011 statute. And again, the requirements of the 2011 statute essentially were that the Commonwealth was going to relinquish any claims to ownership of river bottoms so long as those river bottoms had been filled prior to 1960. They had, in fact, been owned by the Commonwealth, and the purchaser in good faith had acquired those lands. The only issue at trial here was whether Mr. Ferguson had acquired the island and causeway in good faith. There is no evidence other than Mr. Ferguson acquired the island and causeway for value and by a quitclaim deed. At the time, he understood when he purchased the island and causeway in 1999 that the Commonwealth did own the river bottoms. In fact, he attempted a couple of times, as the record shows in the General Assembly, to get the right to purchase those. He never did actually purchase them, but then the 2011 statute comes into effect, and therefore, based on that, he interposed that as a defense to say that I or somebody else other than the Commonwealth owns these river bottoms. And if I or somebody else other than the Commonwealth owns the river bottoms, they are not riparian, and therefore I can't be ejected from them based on the complaint. The final assignment of error related to the court's order requiring Mr. Ferguson to relinquish his property on the island and causeway. The record shows that there was a structure on the property, and the court specifically ordered that Mr. Ferguson transfer, basically, the fee simple possession of the structure in the island and causeway be given to the Bozeman's, and that he be precluded from removing any of his property from the island and causeway. Now, that would have been appropriate, perhaps, if the island and causeway were real estate and the structures were a fixture to the real estate. But by finding that the island and causeway, and therefore the structure, was within the riparian zone of the Bozeman's, well, then the island and causeway and structure could not be real estate. The underlying river bottom is the real estate. The island, causeway, and structure would be analogous to a barge or a boat in the riparian zone, and therefore it would be personal property. So having found that the island and causeway were real estate, or were not real estate, such that the Bozeman's could eject Ferguson from them, the court then said, well, we're going to treat it as real estate, and you have to forfeit it to the Bozeman's. We think that is error. Thank you.
Thank you.
I reserve the rest of my time.
All right.
May it please the court. My name is Carl Bomer. I represent the appellees in this case, the Bozeman heirs. Since 1998, Mr. Ferguson has attempted to take Mrs. Bozeman's riparian rights without paying for them. He's done it by 2 legislative attempts, and he's tried it in 3 court cases. During this time, Ferguson has occupied the island and causeway with no legal right. The 2 very important elements of this case the court is focusing on: the 2008 settlement agreement and the 2010 order. The first suit was settled by a settlement agreement with a mutual release of claims, including Ferguson's release of adverse possession of riparian rights. It provided for immediate dismissal of the suit and the recordation of a riparian plat. Ferguson promised to purchase Bozeman's shoreline property, which would have cleared all the problems up, but he didn't. He breached that agreement. The 2010 order from the second suit.
The first suit was about her riparian rights.
I'm sorry, ma'am, could you speak up a little bit?
The settlement was addressing the suit with regard to her riparian rights?
Yes.
And whether this island and causeway were within her riparian rights. Is that correct?
Part of the settlement agreement, the parties agreed to record a riparian apportionment plat.
So they were deciding her riparian rights, whether his island is in her riparian rights.
Yes, ma'am. Mr. Ferguson agreed that plat correctly showed the riparian zone of Bozeman, and had he performed the agreement, he would have acceded to her riparian rights, and we wouldn't be here today.
Well, my question goes to the issue of whether the statute of limitations had run on her right to seek ejectment, and what in the suit on the riparian rights, or the settlement on the riparian rights, somehow breathed new life into that.
Okay, absolutely not. The statute had not run. Let me turn to that right now. The VMI case is relied on by Ferguson, and Section 8.01230 is the statute that provides for the statute of limitations to run from the time that an injury occurs. That's not applicable here because 8.01230 specifically exempts claims for equitable relief and matters covered by, quote, other statutes.
So your argument is the statute had not run. If the statute had run, if we find the statute had run, what in this settlement agreement would revive it?
I'm not claiming the settlement agreement revived anything. There are two events that triggered new causes of action. The 2010 order was one of them that specifically defined the scope of the riparian area, was one, and his breach of the settlement agreement gave us a right to eject him at that point.
Okay, I'm sorry. Perhaps I'm not being clear. So your claim is not that the statute of limitations had run?
No, it has not.
And my question, sir, is if it had run, is your position that if it had run, there was nothing in this settlement agreement that would have affected that?
I think everybody wiped the slate clean. They gave up their respective claims and so forth. So I think the settlement agreement is significant to that respect. But if I could get back to tell you about the statute of limitations situation here, the applicable statute is 8.01236 that provides a 15-year statute of limitations for ejectment. And that statute provides that it does not start to run until there's a right of entry. And that's been the law of Virginia for 136 years. So the VMI case and 8.01230 talk about personal actions, but they exempt this statute that's been applicable to real estate for 136 years. So the question is, when did the right of entry arise here? That's when the statute of limitations would otherwise start to run. Our position is there can be no right of entry until the boundaries of the riparian zone are defined. When you buy waterfront property, you get a deed with meets and bounds, but the meets and bounds, of course, stop at the low water mark. You have to go to a court of equity to get a riparian apportionment to see where your lines go where it's there. And that wasn't done until later. But the 2010 order did fix the riparian boundaries between the parties. And that was one of the things that gave us a right of entry.
So is it your position,
exactly.
sir, is it your position, if I understand you correctly, what you're saying is the claim for ejectment could not arise until her riparian rights were established by the 2010 order?
That is correct, yes, ma'am.
Okay. And obviously 15 years has not run since 2010.
Sorry?
The 15 years hasn't expired yet.
No, it has not. It has not.
Okay.
There is no statute of limitations as to when you can ask the court of equity to do a riparian apportionment.
So under your theory, this island is sitting in what is obviously part of her riparian rights, has not been defined as to exactly what part. But she can not bring a suit for ejectment, not bring a suit to determine where her rights actually lie for 100 years, and then bring it and the 15 years starts to run once the court says this is where your rights are?
The riparian owner would not be bound to give a riparian apportionment in 1977 when they bought the property. There's nothing in the record to show that there was any adverse claim against Bozeman until Mr. Ferguson came on the scene. That would be a trigger for the statute. He came on the scene in 1998, I believe it was, in December.
Isn't the presence of the island itself the indication of an adverse claim?
In all due respect, you don't know where the riparian zone is. This is a curved shoreline. You can't just assume that you draw parallel lines out from the property corners. You've got to do that riparian apportionment to nail down the meets and bounds of where you are. And the right of entry at the earliest when Mr. Ferguson did the first adverse thing to Bozeman, that is, go to the legislature in 1999 and said, I want your riparian rights. That bill was not passed. He came back again in 2006, and the legislature amended the statute to say, yes, we'll convey Mr. Ferguson the island and causeway subject to the rights of F.E. Bozeman as determined by a court of competent jurisdiction. And we filed suit while that bill was pending in the legislature, and that resulted in the 2010 order. But the statute doesn't start to run until there's a right of entry, and there cannot be a right of entry until, first of all, your rights are defined, and second of all, there's some adverse action toward you to put you on notice. There's nothing in the record prior to Mr. Ferguson's coming in here of any adverse claim that would make the landowner have to go forward and get a riparian apportionment. The 2011 statute, our position is really it's irrelevant in light of the court's prior 2010 order establishing our rights. That 2010 order declared the state owned the bottomlands. It declared Bozeman's riparian rights. It approved the plat. The doctrine of collateral estoppel prevents Ferguson from relitigating any of the facts that were determined in that 2010 order.
But if the facts changed, could he then litigate the issues? The fact in 2010 was the Commonwealth did own the bottomland. Commonwealth then.
The fact.
May I finish my question so that we can?
The answer is no.
Okay. Okay.
No, the answer is no, and here's why. Her rights were vested under the 2010 order. If you allow that 2011 statute to take away her rights, that's a problem. That's what concerned the legislature when they passed this bill, that they'd taken her property without any compensation. But her rights and the rights of the parties were determined and vested in the 2010 order. And that subsequent statute doesn't change that. But the statute doesn't really help Mr. Ferguson anyway, because he does not own any titles to lands. The condition precedent to that statute says titles to lands acquired by a private person in good faith for value, so forth and so on. Ferguson owns no titles to lands. He owns title to a shell pile, but he has no titles to lands. And clearly that statute was passed as a relief act for someone, but it wasn't the Jerry Ferguson relief act. He's already gotten one in 2006. But he owns no titles to lands, and so then he doesn't qualify under the statute.
One more question, counsel. Could anyone ever own title to land if it's built over the Commonwealth's bottom land? Under this particular statute, how could anyone benefit from this particular legislation if whatever they're claiming title to is built over the Commonwealth?
This particular legislation is aimed to benefit, in my view, riparian owners who have property that has been filled prior to July 1, 1960, when the state regulations came into being. And so there might be some question as to the ownership of that shell or fill. This statute applies to Mrs. Bozeman. We didn't assert in the suit, but I think it applies to our client. And at some point in time, we may well assert that.
Counsel, I want to follow on Justice Powell's question because I don't believe it was answered, and I believe it is one of the key questions in the case. Bottomlands the title is owned by the Commonwealth.
That's correct.
When they are filled, that is the situation that this statute is dealing with. Bottomlands that have been filled. Correct?
That's correct so far.
Your interpretation, it seems to me, renders this statute a nullity. Because when one fills bottomlands, absent legislation of this nature, one cannot have title. It would be in fact something akin to personalty. You own what sits on top of the Commonwealth's title. In this instance, it is essentially, it would seem to me, is essentially a statutory quitclaim almost. That the Commonwealth is saying, if you have a claim to whatever it is that sits above what used to be bottomlands, and if it has been sitting there since 1960 or before, then the Commonwealth no longer is claiming title, and you therefore have title. You're able to take this statute and to take your claim and go to a circuit court and argue as the title holder. That would seem to be the only interpretation of the statute that doesn't render it a nullity, that doesn't make it absurd. Is there another interpretation that I could have of this statute that would indicate that the General Assembly actually was doing something?
I was trying to explain that it applies to titles to land, so that is the person who owns the shoreline property is going to get the benefit of this statute.
But this is talking about that which exists above what used to be bottomlands.
Yeah, it's talking about fill.
Okay. Until this statute passed, one could not have title to fill over bottomlands.
I think that's correct. But
Can I intercede here just for a second to see if this helps a little bit? What you're saying is the only person who can get that right is the person who has the riparian rights.
That's right, and on shoreline property, titles to lands. Ferguson had.
Whereas before they couldn't get it either. You know, before Ms. Bozeman would not have owned that, the Commonwealth would have. Whereas now she can claim title to it because she has title to the riparian rights.
Ferguson has nothing. Period. No titles to lands, no right to be out there.
Okay, well, and Counsel, I'm not indicating who has what rights. I'm trying to figure out what the statute means. And you seem to have added a word to it. It seems that you're saying titles to lands that are adjacent to bottomlands that were filled prior to 1960. And the argument in this case isn't over the title to what's adjacent to it. The issue is the rights that one has over what used to be bottomlands. Is that correct?
Yeah, and these are lands in our riparian zone. And they're adjacent. We own titles to lands. Ferguson has no titles to lands. The statute starts with titles to lands acquired by someone in good, faithful value. And
your land is adjacent to what used to be bottomland. Correct.
I think so, yeah.
Okay. The statute doesn't say titles to lands that were adjacent to bottomlands. I'm trying to figure out if the statute says anything at all.
Well, the statute was meant, I think, to benefit riparian owners who had fill in their lands in the past that may have caused a question about title and so forth.
Maybe that was the General Assembly's intent, but I don't know that that's what they've said.
Well, secondly, in addition to the fact that Ferguson owns no titles to land.
Sir, excuse me, but I think you've answered his question. Your time's expired.
I'm sorry?
Your time has expired.
Thank you.
Thank you. Rebuttal.
Thank you. I'll be brief because I've got only 2 minutes. Two issues that were raised on counsel's argument. One, dealing with the statute of limitations. And again, it is our position that the Bozeman's, when they acquired their property in 1977, were put on notice of the island and causeway. The island and causeway were in their, to some extent, within their riparian zone. And it was incumbent upon them at that time, if they wanted to make a claim for ejectment, to do so within 15 years. It is not required that they fully understand the extent of their riparian zone, but only that a portion of the island and causeway is in their riparian zone. And so having failed to act until now, in 2011, the statute of limitations had long expired. Second, again, going back to the 2008 settlement agreement.
Let me ask something. It seems like we're talking about a statute of limitations expiring in the abstract. I mean, doesn't one have to assert a statute of limitations for it to have a meaning? I mean, it doesn't exist in the abstract because it's something that can be waived.
Again, yes, Your Honor. What happens is they have a claim for ejectment. The island and causeway were in the river when they acquired their property. It had been since 1960. And they took no action. They had 15 years to seek to eject the owner of the island and causeway from their riparian zone. That 15 years would have expired in 1992. They took no action during that 15-year period, instead waited until 2011 to file a claim for ejectment. They rely on the settlement agreement, and again, Your Honor referred to that earlier. There's nothing in the release by Ferguson that waives any defenses. It releases any claims he may have against the Bozeman's, but he's not asserted any claims here. He's just raised the statute of limitations as a defense to their claim for ejectment. And so I don't believe that the 2008 settlement agreement would somehow prevent Mr. Ferguson from raising as a defense, which he properly did, the statute of limitations. The other issue dealing with the 2011 statute, it is essentially the titles to land. They become title. The owner, private owner, would become an owner of those lands if they had been filled prior to 1960 and so forth. Apparently, there had been a number of special legislations like Mr. Ferguson had obtained in 2006, and individual property owners were being required to go get special legislation to get their lands. This statute solved that for all those folks that had lands filled prior to 1960. Thank you.
All right, thank you.